So I want you to imagine this. The clock strikes midnight on your 18th birthday.
Right.
You are officially an adult. And, congratulations, right? But what you probably don't realize is that at that exact second, this, invisible, highly protective shield surrounding you just completely shatters.
It's just gone.
Exactly.
Yeah.
Up until this very moment, the legal system looked at you through the lens of the Youth Criminal Justice Act.
Yeah.
If you messed up yesterday, the system's primary goal was basically to shield you, to rehabilitate you, to ask, how do we fix this kid,
Well, the youth system is incredibly paternalistic.
Right. But today,
Yeah.
that paternalistic safety net is completely gone. If the police knock on your door tomorrow, you are playing in the major leagues.
Oh, absolutely. The adult system, it doesn't want to fix you.
No.
It only wants to know if you broke the rules and if so, what the proportional punishment should be. The transition is absolute.
It's terrifying when you think about it.
It is, because it's so unforgiving. The adult criminal justice system assumes you already know the rules of the game. So, if you step into a courtroom and you don't know those rules, the machinery of the state will not pause to teach them to you.
Right.
It is just a cold procedural engine designed to process facts and apply laws.
Which is exactly why we are tearing into the Criminal Law Handbook for self-represented accused today.
Yeah, it's a vital text.
Right. So if you are listening to this, you've hit that milestone, you're 18, your attention is probably pulled in 1,000 different directions right then.
Naturally.
And the last thing you want right now is a dry, dusty legal lecture. So we're throwing out the jargon.
Good call.
We are translating the dense, bureaucratic reality of the Canadian criminal court system into, a pure, fast-paced survival guide.
I like that, a survival guide.
Yeah, we're going to look at the exact mechanics, the hidden traps, and the strategies you need to survive if you ever find yourself staring down the barrel of a criminal charge.
Because the stakes, they honestly could not be higher. A criminal record at 18 alters the entire trajectory of life. It dictates where you can travel, what jobs you can hold,
Right.
and if you aren't a citizen, whether you even get to stay in the country.
Wow.
So to navigate that threat, you have to understand the underlying logic of the system. You can't just memorize what things are. You have to understand how the system thinks.
How it operates.
Exactly. Why it was built this way, and how the state exerts its power from the very first interaction.
So let's ground this in reality rate. Level 1 of the survival guide. Every legal battle starts way before you ever see a judge.
Always.
Let's say you're at a graduation party, things get out of hand, a fight breaks out, a window gets smashed, maybe someone's backpack goes missing.
Classic scenario.
Right. The neighbors call the noise complaint in, and suddenly, flashing red and blue lights are lighting up the front yard. The police walk in.
And that's where the investigation phase ends and the formal charge phase begins.
Okay, so the handbook says this can happen in a couple of different ways, right? You might get arrested and thrown in the back of a cruiser, or the police might just hand you a piece of paper.
Yeah, so that piece of paper is usually a summons, a promise to appear, or an appearance notice.
Right.
And what it does is it officially advises you that you've been charged with a criminal offense. It dictates a specific date and time. You absolutely must present yourself at a provincial or territorial court for fingerprinting and your first appearance.
See, I look at a piece of paper like that and think, okay, the cops are just giving me a glorified parking ticket.
Which is a huge mistake.
Right, because I'm thinking, if they aren't slapping cuffs on me and tossing me in a holding cell, they clearly don't think whatever happened at the party is a big deal.
Right.
I can just show up next month and, pay a fine.
Believing that is honestly one of the fastest ways to end up with a criminal record.
Really?
Oh, yeah. A promise to appear means the crown.
Wait, the crown?
Oh, right. The prosecution. They represent the massive resources of the state. It means they are coming after you for a serious criminal offense. The severity of the charge hasn't been reduced at all.
So why not just arrest me?
Well, the only thing that paper means is that the immediate threat to your physical liberty is temporarily paused.
Wow.
The police officer on the scene made a tactical assessment.
Okay.
They looked at you and determined you're not a flight risk, you aren't an ongoing danger to the public, and they verified your identity.
So the state is still trying to convict me of a crime that could ruin my life. They just, don't want to pay for my meals in a holding cell tonight.
Put bluntly, yeah, that's exactly it.
Wow, okay.
But let's look at the alternative scenario at that party. The police decide you are a flight risk, or the situation is just too volatile.
Right.
They arrest you, read you your rights, and take you into physical custody. The moment those cell doors close, a very specific invisible timer starts ticking above your head.
The 24-hour clock? This is huge in the handbook. It's like a cutscene ending in a video game and the countdown timer suddenly appearing on the screen.
It really is. The criminal code mandates that if you are arrested and held in custody, the police cannot simply let you rot there.
Thank God.
Right. The Crown must bring a bail application. The formal term is a judicial interim release.
Judicial interim release, got it.
They have to bring that before a judge or a justice of the peace within 24 hours of your arrest. Now, there are specific exceptions for the most extreme offenses, like murder.
Right, I assume they don't rush a murder suspect out.
Exactly. For those, jurisdiction shifts to a superior court, but the general rule for almost everything else is a strict 24-hour window.
Okay, let's dig into the why here. Like, why 24 hours? Why not 48? Why not, whenever the local judge gets back from their weekend fishing trip?
Well,
what is the actual philosophy driving that rigid deadline?
it all comes down to the most fundamental principle of a free and democratic society, which is the protection of physical liberty. Think about it. The state holds a monopoly on violence and coercion. If the police could just snatch a citizen off the street and lock them in a cage indefinitely—
Without anyone checking their work.
Right, without a neutral referee looking at the case, you literally have the definition of a police state.
Wow. Yeah, that makes sense.
So the 24-hour clock forces the police to justify their actions almost immediately to an impartial judge. It prevents people from just disappearing into the bureaucratic machinery.
Okay, but how does the judge actually decide? Let's say my 24 hours are up.
Okay.
I'm standing in a courtroom. I'm in an orange jumpsuit. The Crown is arguing I should stay in jail until my trial, which, could be months from now.
Easily months.
And I'm arguing I should go home. What is the actual checklist the judge is using to make that call?
The judge applies a very strict legal test based on 3 grounds for detention.
3 grounds, okay.
The primary ground is attendance in court. The judge basically asks, if I let this person out, will they actually show up for their trial or will they flee the jurisdiction?
Ah, flight risk.
Exactly. So if you have no fixed address, no ties to the community, maybe a history of skipping court dates, you fail the primary ground.
Makes perfect sense. What's the second?
The secondary ground is the protection of the public.
Okay.
So the judge asks, if I release this individual, is there a substantial likelihood they will commit another criminal offense or interfere with the administration of justice?
Like tracking down witnesses and threatening them.
Precisely. For example, if you were arrested for witness intimidation or a violent assault where the victim is your neighbor, releasing you poses a direct, foreseeable threat to public safety.
Right. They're not going to send you back to live next to the guy you just assaulted.
Exactly. And then there's the tertiary ground.
Which is?
This one is more abstract, but it's incredibly powerful. It's about maintaining confidence in the administration of justice.
Okay, what does that mean?
Sometimes the crime is so severe, the evidence so overwhelming, and the public outrage so significant that releasing the accused on bail would make the public lose faith in the justice system entirely.
Oh, wow. So if it's like a horrific crime that's all over the news, letting the guy walk around the grocery store on bail would just enrage the community.
Right. The judge weighs the strength of the Crown's case, the gravity of the offense, and the potential length of the jail term if you're convicted.
So bail isn't just a judge looking at you and deciding if you look like a good kid.
No, not at all.
It is a highly structured, mechanical test of risk assessment. And if you pass those tests, you get released. Maybe with conditions like a curfew or an order to stay away from the kid you fought at the party.
Yes, and that brings up the latter principle in bail hearings.
The latter principle.
The law requires the judge to release you on the least onerous conditions possible.
Okay.
They start at the bottom of the ladder, which is an unconditional release. If the Crown proves that's too risky, they move one rung up to a release with conditions.
Like the curfew.
Right. And if that's still too risky, they add a financial pledge, a surety. It's someone who promises to supervise you and risks losing their own money if you breach your conditions. The judge only climbs as high up the ladder as absolutely necessary to satisfy those 3 grounds of risk we just discussed.
Okay, so let's advance the timeline. Level 2.
Okay.
You survived the 24-hour clock. The judge granted you bail. You walk out of the courthouse. You have a court date set for a month from now, but you are facing a massive problem.
Who is going to fight the actual trial?
Exactly. And here's where we get into the core premise of this entire handbook, representing yourself, the solo boss fight.
In the legal world, you are known as an SRL, a self-represented litigant.
SRL, got it.
And you have an absolute constitutionally protected right to defend yourself. The Canadian Judicial Council explicitly mandates that the court process must be open, transparent, and accommodating to individuals who do not have legal counsel.
Wait, hold on. The handbook says the judge is legally obligated to ensure I get a fair trial. It says the judge has to explain the process to me, make sure I understand the consequences of my decisions, and might even modify the traditional way evidence is presented just to accommodate the fact that I'm not a trained lawyer.
That's all true.
So if that's true, why on earth would I pay thousands of dollars for a defense attorney? I'll just show up, wing it, and let the judge be my safety net. The judge literally has a legal duty not to let me get railroaded.
And that right there is a fundamental misunderstanding of the judge's role. Relying on that will lead you straight to a conviction.
Wait, really? Why?
Because the judge is a referee. Imagine you are playing in a high-stakes basketball game against a team of professionals, and you don't even know how to dribble.
Okay.
The referee will absolutely make sure the professional team doesn't foul you. The referee will explain that you have to stay within the lines of the court. The referee will ensure the shot clock is run fairly.
But they aren't going to pass me the ball.
Exactly. They will not tell you what plays to run. They will not point out the gaping hole in the other team's defense. They cannot give you strategic legal advice, and they cannot, under any circumstances, abandon their impartiality to give you an unfair advantage just because you are outmatched. If you fail to object to inadmissible evidence, the judge might intervene if it's egregious, but they cannot try your case for you. They hold the baseline of fairness. They do not guarantee your success.
That is a terrifying reality check. And the handbook outlines strict rules of engagement if you go solo, right? Like, you can't just act out.
No, you have a legal obligation to be respectful. You cannot be frivolous, vexatious, or abusive. You cannot waste the court's time because you failed to do basic homework on courtroom procedure.
So no dramatic courtroom antics.
Definitely not. If you show up unprepared, rolling your eyes, interrupting the Crown prosecutor, or ignoring the judge's directions, you will rapidly exhaust whatever procedural patience the court extends to an SRO.
So let's talk about the collateral damage of losing that game. Because at 18, you're probably just thinking about jail time or a fine. But the handbook has this entire worksheet of questions you need to ask yourself before you definitively decide to go solo.
Right, because the hidden consequences of a criminal record are often way more devastating than the sentence itself.
Like what?
Well, will this conviction prevent you from ever crossing the border into the United States? Will it trigger a suspension of your driver's license, causing your insurance premiums to quadruple? Does the offense involve a mandatory weapons prohibition, meaning you can never go hunting or work in certain security jobs?
Man, the ripple effects are huge.
And perhaps the most terrifying hidden consequence, if you are a permanent resident or an international student, a specific type of conviction can render you criminally inadmissible to Canada.
What does that mean in plain English?
It means the judge sentences you to a small fine, but the immigration authorities use that conviction to deport you.
Oh, wow. So you pay your $200 and then you get kicked out of the country. So if you're listening right now thinking you can just outsmart the system with a quick Google search and a charming smile, understand the actual weight of the machine you are stepping into.
It's heavy.
Which brings us to level 3, the next massive hurdle. You've decided to go solo. You are standing in your kitchen, you open the envelope the police handed you at the party, and you are staring at the actual charge.
Okay.
To a normal person, it just looks like legal gibberish, right? Assault causing bodily harm, mischief under $5,000. But the handbook says there are actually 3 highly distinct categories these charges fall into.
Yes.
And depending on which bucket your charge is in, the entire future of your legal process is completely different.
The Criminal Code divides offenses into 3 procedural streams: summary conviction offenses, indictable offenses, and hybrid offenses. Understanding the difference is the first real test of a self-represented accused.
Let's use an analogy our 18-year-old listener is very familiar with: high school discipline.
I like this.
A summary conviction offense is like getting detention. It's the lowest tier.
Right. Summary conviction matters are exclusively heard in provincial court. The procedural rules are more streamlined, the trials happen faster, and critically, the maximum penalties are capped.
How capped?
Historically, summary offenses carried a maximum penalty of 6 months in jail and a $5,000 fine. Though recent legislative updates have increased the maximum jail time for many summary offenses to 2 years less a day.
Still, they are the least severe category of crime.
Yes. Another defining feature is the limitation period. The pleas generally only have 12 months from the date the offense occurred to lay a summary conviction charge.
Okay, so that's detention. The next tier is the indictable offense. This is getting expelled. This is the heavy artillery.
Indictable offenses are the most serious crimes in the criminal code. Murder, aggravated sexual assault, treason.
Treason, wow.
Yeah. And there is no statute of limitations on indictable offenses. The police can charge you 20 years after the fact.
So they can just wait you out.
Exactly. These cases are escalated to the Superior Court of the province. And this introduces one of the most strategically complex decisions an accused person must make, which is the election.
The election. The handbook spends a lot of time on this. When you are facing an indictable offense, you often get to elect or choose the mode of your trial.
Yes.
You can choose to be tried by a provincial court judge, a superior court judge sitting alone, or a superior court judge sitting with a jury.
Right. So imagine being an 18-year-old facing a massive charge, and the court asks you to choose your battlefield. Most people instantly assume they want a jury.
I would.
They want 12 regular citizens who might sympathize with their story, who might see them as a kid who made a mistake at a party, rather than a hardened criminal.
Exactly. A jury feels human. A judge feels like a machine. Why on earth would I ever choose to have a single judge decide my fate when I could roll the dice with 12 regular people?
Because regular people are susceptible to emotion. And emotion is dangerous if the facts look bad for you.
Well, that's a good point.
Juries can be outraged by the nature of the crime, regardless of the strict legal definitions. A judge is a professional mechanic of the law.
Okay, give me an example of when a judge is better.
Let's say your entire defense hinges on a highly technical argument that the police violated your charter rights when they searched your backpack.
Right.
You aren't arguing that the drugs weren't in the backpack. You were arguing the search was constitutionally illegal.
I see.
A jury struggles to ignore the drugs. They just see drugs and think guilty. A judge is trained to clinically exclude the drugs from their mind if the search was unlawful. Sometimes, a cold, emotionless analysis of complex case law is your only path to an acquittal.
That's a massive strategic pivot. You really have to know what kind of game you are playing. And for the really severe indictable charges, the handbook mentions a preliminary inquiry. What is that? Like a practice trial?
It functions like a screening mechanism. For indictable offenses that carry a maximum penalty of 14 years or more, and Parliament has strictly limited this recently to unclog the courts, you can request a preliminary inquiry in provincial court before your actual trial in superior court.
So what happens there? Do you win or lose?
The judge doesn't decide if you are guilty or innocent here. The judge only asks, does the Crown have enough evidence that a reasonable jury, properly instructed, could possibly convict?
Oh, so it's a filter.
Exactly. If the Crown's case is incredibly weak, the judge discharges you, and the case never even goes to trial.
That's awesome.
It is. And it's also an incredible strategic opportunity for a self-represented accused to cross-examine the Crown's witnesses under oath, locking down their testimony months before the real trial begins.
Okay, so summary is detention. Indictable is expulsion. What is the third flavor? Hybrid.
A hybrid offense is exactly what it sounds like. It is an offense that can be prosecuted either as a summary conviction or as an indictable offense. Assault, theft under $5,000, impaired driving, these are all hybrid offenses.
So who makes the call? Do I get to choose? Does the judge decide?
Neither. The Crown prosecutor holds the exclusive power to make that election.
Wait, the prosecutor?
Yes.
The person whose entire job is to secure a conviction against me gets to decide if we are playing for low stakes in provincial court or high stakes in superior court. That sounds like an insane amount of leverage.
It is the ultimate leverage. Let's look at the game theory of the criminal justice system here.
Yeah, please.
The Crown looks at your file. They look at the severity of the broken window at the party. They look at whether you have a prior record. They look at court resources. If they elect to proceed by summary conviction, they signal that they view this on the lower end of the spectrum. But the Crown can also use their election power strategically.
How so? Like as a threat?
Precisely. The Crown might initially treat the charge as indictable, the heavy artillery. You are suddenly facing superior court, complex elections, and massive maximum penalties. You panic.
Obviously.
Then, behind closed doors, the Crown offers a deal. They say, if you agree to plead guilty right now, we will drop the procedure down to a summary conviction. You take a fine instead of risking years in prison.
Oh my God. The sheer threat of the indictable process is used to negotiate a swift guilty plea.
Yes.
So the principal looks at your file, threatens you with expulsion, but says, if you admit you did it right now, I'll just give you detention.
That's exactly how it works.
The pressure to cave must be overwhelming, especially if you are 18 and terrified.
Which is why understanding these mechanics is so crucial. You have to know what the Crown is capable of doing to evaluate whether a plea deal is actually a good offer.
Yeah.
Or just a tactical bluff.
All right, let's say you don't take the bluff. You are proceeding to trial. You know your charge. You know the battlefield. But you are flying blind. You know what happened at the party, but you have no idea what the police actually wrote down.
You don't know who they talked to.
Exactly. How do you fight an enemy when you can't see their weapons? And this brings us to level 4, what I consider the absolute ultimate cheat code in the Canadian legal system.
The right to disclosure.
Yes. When I read this section of the handbook, it completely shifted how I view the justice system, because the reality is you don't have to guess what evidence the cops have against you. You literally just ask for it.
It is a fundamental constitutional right established by the Supreme Court of Canada in a landmark case called R.V. Stinchcombe.
Stinchcombe?
Yeah. And the rule is staggering in its simplicity and power. The Crown must hand over all relevant information in their possession or control to the accused, whether they intend to use it at trial or not.
Let me make sure the listener really grasps the magnitude of this. It is like you are playing the rival school for the state championship. And legally, weeks before the game, you can force the rival coach to hand you a binder containing their entire playbook. Every single play they plan to run.
Yes.
But not just that, they also have to give you the scouting reports that highlight their own team's weaknesses.
The analogy holds up perfectly. The Crown must provide you with a copy of the police occurrence reports, the officer's handwritten notebook entries, all witness statements, 911 audio recordings, video surveillance footage, and forensic reports.
It's a gold mine.
It is. And the critical point you raised, they must disclose the evidence that destroys their own case.
Which is wild.
If the police interviewed 3 people at the party, and 2 said, yeah, the 18-year-old smashed the window, but the third person said, no, it wasn't him. I clearly saw a guy in a red hoodie throw the rock.
The Crown cannot bury that third statement.
Absolutely not. They are legally mandated to give it to you so you can use it to defend yourself. The Canadian system fundamentally rejects the concept of trial by ambush.
But why? Why does the massive, powerful government, with all its police funding and prosecutors, have to play a game of poker with their cards facing up, while the accused gets to keep their cards hidden?
It all traces back to the golden thread of criminal law, which is the burden of proof.
Right.
The Crown must prove your guilt beyond a reasonable doubt. You, the accused, do not have to prove your innocence. You do not have to prove that someone else broke the window. You are presumed innocent.
Because the state has the immense, terrifying power to deprive you of your liberty.
Exactly. The law demands an equalizing mechanism. Disclosure levels the playing field. It ensures that if the state is going to cage a human being, they are doing it based on the whole truth, not just a selectively curated narrative.
Okay, so the Crown hands you a massive stack of papers, a thumb drive full of videos. You have the disclosure playbook.
Now the work begins.
Yeah, like what are you actually looking for? How do you read this mountain of information and extract a defense out of it? The handbook talks about breaking the crime down into its core components. And we get to these 2 Latin terms that sound like ancient spells, actus reus and mens rea.
They are the DNA of every criminal offense. To secure a conviction, the Crown must almost always prove that 2 things existed simultaneously.
Okay.
The first is actus reus, which translates to the guilty act.
The physical reality of what happened.
Exactly. Did your fist connect with the victim's jaw? Were the stolen electronics physically located inside your backpack?
Yeah.
The actus reus is the objective, observable conduct that the law prohibits.
But the handbook makes a massive point that doing a bad physical thing is rarely enough to make you a criminal.
This is where the law becomes intensely psychological. The Crown must also prove the mens rea, the guilty mind. They have to prove your internal intent at the exact moment the physical act occurred.
Okay, let's go back to the graduation party to explain how you use this to boot a charge.
Let's do it.
Let's say the police raid the party. It's dark, it's chaotic. Someone shoves a stolen phone into your hand, you panic, stuff it in your pocket, and the cops grab you. The disclosure playbook has a video showing you clearly holding the stolen phone.
Yeah.
The physical act, the actus reus, is caught on 4K video. You possess stolen property. If you don't know the law, you look at that video and think, I'm dead. I have to plead guilty.
But a self-represented accused who understands mens rea looks at that video completely differently.
Because you don't argue with the physical act.
Right. You say to the judge, yes, Your Honor, that is my hand and that is the stolen phone. The actus reus is established. But look at the context in the disclosure. The lights were off, people were running. I was handed an unknown object and instinctively pocketed it to keep my hands free.
So I didn't mean to steal it.
Exactly. The Crown has presented absolutely zero evidence that I had the specific intent to deprive the owner of their property. I did not have the mens rea. I had no idea what was in my pocket.
You separate the mind from the body. You prove that a mistake, an accident, or sheer ignorance eliminates a criminal intent. You use their own disclosure to show what is missing.
You comb through the witness statements looking for inconsistencies. You look for officers who failed to document crucial details. You are hunting for reasonable doubt.
But what happens if the police didn't collect the evidence that proves your innocence?
That's a great question.
What if the key to your defense is held by a hospital or a high school or a psychiatrist? This blew my mind in the handbook. It outlines a weapon called an O'Connor application.
Yes, the O'Connor application.
Let's say the person accusing me of assault at the party has a known history of severe, violent hallucinations, and their psychiatrist has the files proving it.
Okay.
The police don't have those files. The Crown doesn't have them. How does an 18-year-old force a doctor to hand over confidential medical records?
You file an O'Connor application. It is a formal legal mechanism to demand that third-party records be produced in court. But it's not a fishing expedition. You can't just demand random files hoping to find dirt.
Right.
You have to satisfy a complex legal test before the judge. You must convince the judge that the records you are seeking are likely relevant to an issue at trial or the competence of a witness to testify.
So you have to connect the dots. You have to tell the judge, I am not asking for these medical records to embarrass the witness. I'm asking for them because they contain documentation of a psychiatric condition that directly affects this witness's ability to perceive reality on the night of the party.
Yes.
Which is the entire foundation of the Crown's case against me.
And if you articulate that legal argument successfully, the judge will order the third party to produce the records to the court.
Do you get them right away?
No. The judge will review them privately first, and if they are truly necessary for you to make full answer and defense, then the judge will hand them over to you. You are actively utilizing the power of the court to build your own evidentiary arsenal.
Which brings us to level 5. The actual mechanics of the courtroom. You have your disclosure. You've mapped out the mens rea weaknesses. You've got your third-party records. It's time to step onto the battlefield. We are entering the pregame setup, which is pleas and charter rights.
The initial procedural hurdle is the arraignment. You stand before the judge, the clerk reads the formal charges against you, and you are asked to enter a plea.
Guilty or not guilty, it sounds like the easiest part of the process.
The simplicity is really deceptive, because the gravity of uttering the word guilty is absolute. When you plead guilty, you are not just saying, yeah, I was there. You are formally, legally admitting to every single essential element of the offense. You are admitting the physical act. You are admitting the mental intent. You are waiving your constitutional right to a trial. You are waiving your right to hold the Crown to their burden of proof.
It's game over.
It is. The judge is actually required to conduct a plea inquiry to ensure you are doing this voluntarily, that you fully understand the consequences, and that no one forced you or promised you anything in exchange. Once the judge accepts that guilty plea, you proceed directly to sentencing.
What if I freeze?
What do you mean?
What if I'm an 18-year-old standing in front of a judge in robes? The prosecutor is glaring at me, the courtroom is full of people, and I just get total stage fright. I clamp my mouth shut and refuse to speak. Does the judge assume I'm being defiant and just mark me down as guilty?
No, and this is where the system's default settings actually protect the accused. If you stand there and remain totally silent, or if you refuse to plead, the judge will not hold it against you.
Oh, thank goodness.
By law, the court must enter a plea of not guilty on your behalf. The system defaults to forcing the state to prove its case.
That is a massive relief. Okay, so you plead not guilty. The trial date is set. Now, the handbook talks extensively about the Canadian Charter of Rights and Freedoms.
It's vital.
This is the supreme law of the land that protects citizens from government overreach. And this brings up a huge TV trope I really need to clarify.
I think I know where you're going with this.
Let's go back to the party. The police show up for a noise complaint. I'm standing in the kitchen with my backpack zipped up. A police officer walks over, unzips my backpack without asking, rummages through it, and finds illegal drugs.
Okay.
Now, I know my charter rights. I know Section 8 protects me against unreasonable search and seizure. The officer had no warrant, no probable cause, no emergency. It was a completely illegal search.
Understood.
So I'm at my trial. I'm acting as my own lawyer. The prosecutor calls the police officer to the stand. The officer says, "I found the drugs in his bag." Do I wait for that exact moment, dramatically stand up, slam my fists on the table, and yell, "Objection, Your Honor"? The officer violated my Section 8 charter rights. I demand this evidence be thrown out.
If you try to pull off that dramatic television moment in a real Canadian courtroom, you will lose. The drugs will be admitted into evidence, and you will likely be convicted.
Seriously, why? The search was illegal.
Because the reality of criminal law is deeply bureaucratic, and procedure governs everything. You cannot ambush the Crown or the judge with a complex constitutional challenge in the middle of a trial.
So they just don't have time for it right then.
Determining whether a search violates Section 8 of the Charter requires a nuanced legal analysis. Was the search authorized by law? Is the law itself reasonable? Was the search conducted in a reasonable manner? The court has to hear arguments on all of this, and usually the officer needs to be questioned specifically about their state of mind during the search.
So how do you actually enforce your rights if you can't just yell objection?
You have to fight the battle before the trial even begins. If you believe your charter rights were violated, you are required to file a formal written notice of application well in advance of the trial date. Exactly. You must serve this notice on the Crown prosecutor and file it with the court. This notice must outline exactly which charter right was violated, a summary of the facts, and the specific remedy you are seeking.
Which would be what in this case?
Under Section 24, subsection 2 of the Charter, it would be the exclusion of the illegally obtained evidence.
Timing is everything.
Timing is the difference between freedom and jail. These constitutional issues are often hashed out months before the trial during pretrial conferences. The Criminal Code, specifically Section 551.1, allows for the appointment of a case management judge.
What does a case management judge do?
This judge will look at your charter application and might order a voir dire.
A voir dire.
It's basically a trial within a trial, solely dedicated to determining the legality of the backpack search. If you win that mini trial, the judge rules that admitting the drugs would bring the administration of justice into disrepute.
And then?
The evidence is thrown out. The Crown suddenly has no drugs to present at the actual trial, and their case collapses.
But if I miss the paperwork deadline?
If you fail to provide proper notice, the trial judge has the discretion to refuse to hear your charter argument entirely. You effectively waive your constitutional rights because you didn't follow the procedural rules. The illegally obtained evidence gets used against you.
The lesson here is that the real legal battle is fought in the paperwork, not in the dramatic courtroom speeches. You have to anticipate the Crown's moves and dismantle them procedurally.
Exactly.
Okay, let's fast forward to level 6. You've filed your paperwork, you've cross-examined the witnesses based on your disclosure playbook, you've argued the mens rea, the trial is over, the judge retires to chambers to make a decision. What are the actual outcomes at the end of the line?
There are several potential outcomes. The most straightforward is an acquittal. The judge determines that the Crown failed to meet the standard of proving guilt beyond a reasonable doubt. You are found not guilty. You walk out the front doors of the courthouse completely free.
The ultimate victory. And the opposite.
A conviction. The judge finds that the Crown proved every element of the offense beyond a reasonable doubt. A conviction triggers the sentencing phase, where the judge determines your punishment.
Which could be anything from a fine to jail.
Right, ranging from a monetary fine to probation or a period of incarceration.
But the handbook spends a fascinating amount of time detailing 2 other specific outcomes that fall into this weird gray area. They are called discharges, absolute discharges, and conditional discharges.
Yes.
Let's break these down because they sound incredibly relevant for an 18-year-old first-time offender.
A discharge is a unique mechanism in Canadian law where the court finds you guilty. So the facts are proven you committed the offense. But the judge decides that formally convicting you is not appropriate.
Okay, how does a judge justify that?
The legal test the judge applies is twofold. Granting the discharge must be in the best interests of the accused, and it must not be contrary to the public interest.
So how does an absolute discharge work? I read the handbook's definition, and it genuinely sounds like a literal get-out-of-jail-free card.
Essentially, it is. Let's say you were found guilty of a very minor theft. You have no prior record, and you are about to start university.
Okay.
The judge looks at the situation and decides that burdening you with a permanent criminal record is wildly disproportionate to the minor nature of the crime. If the judge grants an absolute discharge, you receive no fine, you serve no jail time, you have no probation.
And the record.
Crucially, a conviction is not registered against you. After 1 year, the record of the discharge is automatically purged from the federal RCMP database. You walk away clean.
You literally win even when you lose. The judge says, you did it, but I'm not going to ruin your life over it.
Basically, yes.
What about the conditional discharge? I viewed this one like being put on strict academic probation by the dean.
The academic probation analogy is spot on. With a conditional discharge, the judge again finds you guilty. But instead of registering a conviction, they place you under probation order for a specified period, say 12 or 18 months.
And this order comes with rules.
Strict rules. Standard conditions include keeping the peace and being of good behavior. But the judge can add specific conditions tailored to the offense. You might be ordered to complete 50 hours of community service. You might be ordered to attend anger management counseling or stay away from someone, right? You might be ordered to stay at least 100 meters away from the kid you fought at the graduation party.
And if I follow all the rules.
If you successfully navigate the entire probationary period without breaching a single condition, the discharge becomes absolute. The bad grade is wiped from your transcript. 3 years after the completion of the probation order, the record is purged.
But it's a tripwire. What happens if I'm 6 months into my probation and I run into that kid at a coffee shop and yell at him, violating the no contact order?
You trigger the trapdoor. The state will arrest you for a new offense, which is breach of probation. But worse, the original judge can revoke your conditional discharge, register the formal conviction for the original party fight, and sentence you to jail for it. A conditional discharge is an incredible second chance.
Yeah.
But it requires flawless execution.
I want to highlight something profound here as we wrap up this survival guide. Throughout this entire process, from the 24-hour bail clock to analyzing the charges to digging through disclosure to fighting charter violations, there is a massive, empowering psychological shift that happens when you truly understand the system.
There really is.
And it's this. You can win a trial without ever saying a single word in your own defense.
That is the ultimate realization of a self-represented accused.
You never have to take the witness stand. You never have to call a friend to testify for you. You never have to construct a flawless alternative story of what happened at the party.
Because the burden of proof rests entirely on the crushing weight of the state. Your job is not to build a fortress of innocence. Your job is simply to find the structural cracks in the Crown's narrative and pry them open. If your cross-examination of the police officer exposes a lie, or if your analysis of the mens rea shows the intent is missing, or if you successfully exclude the physical evidence through a pre-trial charter application, you introduce reasonable doubt into the mind of the judge.
And the moment reasonable doubt exists, the machinery of the state halts. You win.
You win.
So let's do a rapid-fire recap of the Adult Survival Guide. First, the 24-hour bail clock. The moment the cuffs go on, the state has 1 day to justify to a neutral judge why you pose a risk to society, or else you go home.
Right.
Second, going solo. You have the right to represent yourself, but the judge is a referee, not your coach. They will enforce the rules, but they will not run your plays.
Crucial distinction.
Third, decoding the charges. You need to know if you are facing a summary detention, an indictable expulsion, or if the Crown prosecutor is holding the hybrid leverage cards to force a plea deal.
Know your battlefield.
Fourth, the ultimate cheat code. Demand your disclosure playbook. You have a constitutional right to see every single weapon the state plans to use against you, including the evidence that proves your innocence. Use it to attack not just the physical act, the actus reus, but the mental intent, the mens rea.
The mind and the body.
And finally, courtroom mechanics. Do not wait for a TV-style gotcha moment. If the police violated your charter rights, you must fight that battle in the pretrial paperwork. Timing is the difference between an acquittal and a conviction.
The overarching theme here is that knowledge is your absolute best defense. The system relies on the ignorance of the accused to process cases quickly. When you understand the mechanics, you slow the machine down and force it to prove its power.
If you are listening to this right now, understand this. The training wheels of the youth system are off. The adult system is cold, it is highly procedural, and it is entirely unforgiving. But it is still a machine. And like any machine, it runs on very specific, hackable rules. Knowing those rules is quite literally the difference between keeping your freedom and losing it.
Well said.
Before we sign off, I want to leave you with a provocative thought to mull over. Think deeply about that concept of disclosure we spent so much time on.
Yeah?
The legal system absolutely requires the massive, powerful government to hand over all their evidence to you. Even the evidence that proves you are completely innocent. Even the evidence that makes the investigating police officers look incompetent, sloppy, or corrupt.
It's a striking rule.
It is. Why did we design a justice system that intentionally forces the prosecution to hand their best weapons and their most devastating weaknesses to the very person they are actively trying to put in a cage? What does that paradox tell you about the immense, terrifying power of the state? And more importantly, what does it tell you about the extreme, almost unnatural lengths a free society must go to in order to even slightly level the playing field against its own government?
It forces us to ask whether the system is truly designed to seek the truth or simply to act as a check on its own immense power.
Something to think about the next time you see those flashing red and blue lights. Well, we'll catch you next time on The Deep Dive.